in 2010 when the EAC Council of Ministers approved the cyber law framework, the EAC cyber law framework. That framework guided East African Community member states on what laws were necessary for the development of an appropriate cyber law or cyber legislation framework. These laws included the Computer Misuse Act, which I know is very popular lately, but I'm happy that's not what we'll be discussing today. It included the Electronic Transactions Act, it included the E-Signatures Act, and of course, the Data Protection and Privacy Act. If you'll note, the three laws I mentioned first, the Computer Misuse Act, the Electronic Transactions Act, the E-Signatures Act were all passed in 2011. We started developing the Data Protection and Privacy Act in 2006 or thereabout. That's when we did the principles. It then took us about 5 years, 4 to 5 years, for us to progress to the point when Parliament approved or passed the Data Protection and Privacy Act in 2019, and subsequently it was assented to by the President in May 2019 and took effect. After that, the regulations were drafted, and these regulations were gazetted in March 2021. And following that, the implementation actually started in August 2021, when following appointment as National Personal Data Protection Director, and I'm charged with the responsibility to lead the Personal Data Protection Office in Uganda. So since then, we've been doing a lot of work. Some of that work has been supported by UNCDF in terms of digitizing some of the requirements. For instance, registration. We've been doing a lot of awareness, and of course we now have a number of organizations that have started implementing their data protection and privacy frameworks. I think briefly, that is the history of data protection and privacy in Uganda.
Thank you, Stella. You mentioned that you started implementation in August of 2021, and I do remember towards the end of 2021, there was a notice issued for organizations or persons who are data collectors, processors, and what's the other one? Data collectors, processors, and
controller.
Thank you. To register with the PDPO, and there was a deadline for December 2021. I do remember that was the deadline, and then it was not automated as it is now. So I'm wondering, how is compliance, or what's the landscape looking like in terms of compliance since the implementation of, especially when the regulations came into force? What's the landscape looking like in terms of compliance and your office ensuring that people are actually getting registered, but also complying with the Data Protection and Privacy Act?
Indeed, we issued a notice. That deadline was December 2021. But of course, after that, we received a number of pleas to extend that deadline. We also noted that because the submissions were not digitized, it was also quite difficult for many agencies to complete that registration process. We used that as a learning process for us, and through the support of UNCDF, we were able to develop a portal, our office portal, and that portal has enables registration of all organizations. The entire process is digitized, from you submitting your documents, back end us reviewing the documents, you paying for that certificate, us issuing that certificate. It's all digital enabled, and organizations can even print their own certificates. So while initially we had to receive paperwork and sign, I had to physically sign certificates. Today I no longer sign any certificate, because the minute I approve that registration application, automatically that certificate goes to the company, and they are able to print it on their own if they want. Following that system, we saw a jump in registrations. We currently have over 500, about 525 organizations that are registered. Of course, through that initiative, this register is also public. So if someone is collecting your personal data, you can actually check and see if they are registered. Within the private sector, we have organizations, especially the banking sector, has been very compliant, very proactive. We've found that I think close to even 95% or 99% of our banks are already registered. We've also seen great strides with insurance companies. The government is still slow, although towards the end of July, a circular was issued by the PS Ministry of ICT and National Guidance, requiring all MDS to register. And we've seen some traction in that regard. In terms of compliance, we've seen that working with regulators really gets things moving. We have a very good working partnership with BOU, and I think it explains why almost all the banks are registered. We have a good relationship with the insurance regulator. We've recently engaged the NGO Bureau, and all NGOs have also been requested to register as part of their compliance program with the NGO Bureau. So there's a lot of traction. In May of 2022, May 2022, that portal also enabled the receipt of complaints, because the office also receives complaints. Between May and September, we're able to get 1,700 complaints that we've had to review individually. For us, that what tells us is that people are now more aware of their rights. What I can say is that while, yes, we make effort to talk about these issues in our local languages, we still need to do a lot of work for our rural communities, and those are some of the things we are working on. To really determine how we are progressing in 1 year, I think we are doing fairly well. There's a lot of information that we provided on our various media channels. On our YouTube channel, there's a lot of content, because on a monthly basis, since the office was started, we've been having a session every month where we talk about topical issues about data protection. It could be the role of a data protection officer. This month, we are talking about how to develop a data protection and privacy policy. We've talked about how to secure personal data and many, many other things. So I believe the future is bright, and all we need is as much support as we can get to ensure that for all of those who are hearing us, individuals, if you have your personal data and it's being collected, please try and find out, is this organization registered? Why we are emphasizing registration is because when we know who you are and what you're doing, who your data protection officer is, it is much easier for us as an office to support you to ensure your compliance.
Thank you, Stella. We as KTA commend you and the office for the last Thursday of the month. I think that's when they happen. The trainings. I missed the one of yesterday for obvious reasons, but I'm sure I'll find the recording. I would say as a practitioner in the area, every other last Thursday of the month, I learn something new, and it's very, very interesting. So this week on Tuesday, some members of our law firm were privileged to attend a demonstration by NITA and for the UG Pass, which is really certifies and issues electronic signatures. And I know that there are several technologies involved there, and they reiterated that they're registered with the PDPO. My next question really is about what the PDPO is doing in light of emerging technologies such as AI.
For us as the PDPO, our focus in terms of emerging technologies is to ensure developers in that space incorporate data protection and privacy issues. Basically implement what within the privacy space is called privacy by design. We also need to know that at the ministry level, a lot of efforts have been made to incorporate these aspects. For instance, the ministry recently developed the 4IR policy. I'm aware I think it hasn't yet gone to cabinet, but in our comments on that policy, we made sure that issues of data protection and privacy are provided for. Within that policy, there was a recommendation for Uganda to develop the national data strategy. The last 3 or 4 days, I was in Jinja talking about these issues of privacy within a space that had data scientists, innovators, a lot of people who develop much of this technology. And I stressed the need within that data strategy to ensure that we provide for these, for data protection and privacy. So currently, it's more into the policies, ensuring that the policies, especially those that are coming out of the Ministry of ICT and national guidance, take into consideration issues related to data protection and privacy. Secondly, in our engagements with various stakeholders, we are advocating for the implementation of privacy by design as a methodology for any technology that is being developed. We are cognizant that these emerging technologies are around us in all organizations, whether it's banks, whether it's government bodies, whether it's universities, they are all around us. So that is the effort we are making to ensure that privacy is taken care of as we develop these technologies and ultimately develop Uganda as our country.
Thank you. To piggyback on that, for my last question at the moment, is that the challenges that the office is facing, and also particularly regarding cross-border transfer of data.
Of course, as a new office, we have the usual challenges, and I wouldn't want to sing that song. I'm sure many of us would guess what I would say. Issues of funding, very few resources at the office, but we are trying to work with what we have and deliver the service that we are required to provide. Of course, I talked about the fact that the bulk of our rural communities don't understand issues to do with privacy, and we can only talk about them in the languages that we speak within the office. This is Luganda, Runyachitara, and a bit of Itesot. Outside of those languages, we are not able to really talk about these issues, but we are engaging development partners, we are engaging government to ensure that we get funding to be able to provide these tools that will enable us understand where we are, what our rights are, and what the obligations are. In terms of cross-border flows of data, I think it's important for us to talk about what is happening globally or within the African Union. I know many of us know that recently, in February 2022, the Council of Ministers, the Executive Council of the African Union, passed the AU Data Policy Framework. Within that framework, the AU advocates for cross-border data flows and has provided a lot of recommendations and recommendations for member states to be able to implement within their own organizations. Of course, one of the challenges that we have is that when you talk about cross-border data flow, there's an issue of sovereignty. How do countries manage their own data? How do they have control over their data? And that framework has been able to provide some recommendations. What is very important is that the framework also recommends that those people who are collecting data ensure that the African member states also benefit. That equitable distribution has been lacking in this space. So those are some of the recommendations that have been made. Secondly, still at the African level, there has been a lot of effort to harmonize our data protection laws. I'm a member of a working group which is supported under the PRIDA program, where we sit as data protection commissioners to discuss harmonization of our laws. Because we know once our laws are harmonized, it will be very easy for us to have this data flowing within the different countries. Within Uganda itself, the Data Protection and Privacy Act does not bar organizations from sharing or transferring data abroad, but it requires that that organization ensures that the country that is going to receive this personal data has adequate security measures that are similar to what our law provides. If that is not possible, then those organizations are required to obtain the consent of that data subject whose information they are collecting. As an office, we regularly receive requests for legal opinions on how can we do this. I'm sending my information to Latvia. Is this an adequate, does it have adequate protections? We've not been able to analyze that yet, but the law allows us to give guidance on that, and we'll be able to do that in due course. Thank you.
Thank you, Stella. I'll head over to Richard, who is the Technical Advisor, Inclusive Digital Economy at UNCDF. I'm still hoping you'll tell us a thing or two about yourself. But my first question to you is, how important is it to have a strong data protection framework within the digital economy?
Yes, thank you. Good to be here next to Stella. Once again, good to be in your company. Yes, I work at UNCDF. I work for the digital program at UNCDF as a technical advisor. I am not an expert in data privacy, but I work in the digital economy space. So we, at UNCDF, the digital program that I work for, all that we do is try to get digital to work for the lower income segments of the population. So in Uganda, we're trying to get people to innovate for the low income segments. We are trying to get farmers to use technology to improve their productivity. And we're trying to find out how new business models can improve the livelihoods of low income, underserved people. When it comes to data privacy and data privacy frameworks, and that's also the genesis of how we started to work with the PDPO, is that we believe that if you're on the track to introduce digital to the people, then you should be able also to tell them about the likely risks that that comes with. And one of the risks is indeed the one around data privacy and protection, and that's how we came to work with the PDPO to build the trust that is needed in digital services. The users need to be able to trust that there are no side effects, if I might use that word. And as you might all know, I think the biggest thing to build is trust. I could also tell you that one of the biggest challenges we face in trying to get digital services to diffuse down to the lower income segments is an issue of, one is trust, of course, knowledge. Low knowledge leads to little trust, and if I don't trust something, it's hard for me to uptake of it. So we struggle a lot and invest a lot in getting digital to go down, down market, and it would be absurd if small challenges of leakages of data privacy reverse achievements that we've worked for very long to achieve in driving down digital. So the biggest dividend for data protection, privacy and protection frameworks is building trust in the digital economy. And we try to inculcate that in a lot of what we do. But number two, and this is linked to new business models in the digital space. There's some people who say that if you don't pay for a product, then you're the product, okay? The digital space today, we are the products, and we meaning our data that people hold. We consume a lot of free digital services. It means we are the products. Now, ultimately, the owner of the data is ourselves, but we need to be empowered to actually gain control of that data. So such frameworks really bring to the forefront, one, the fact that we are the masters of our data and should be able to claim to know what that data is used for, how it is used, and all. So the frameworks really help us to gain that control as users, but also for those using the data to be cautious about how they use it. And this will take me to the aspect of most of the Ugandans don't even know what they are entitled to when it comes to the whole issue of data privacy. But if we build compliance by the providers, then we're actually helping those that don't have enough information about it. So building compliance from the supply side and building awareness from the demand side, and all that enabled by a framework like the one we have in Uganda today, I think will take us far. So what does that build? It builds confidence in businesses that are relying on data to build new business models. And I'll give an example. A lot of the digital services offered in Uganda, in our countries, require external investment. Investors are coming from abroad. Now, if my business is built on monetizing data, it will be very hard for me to get an international investor to come and invest in me if there is no clarity on the regulation around data. Again, that's one of the dividends of having a framework. So if the framework is clear in a country, it gives certainty to the one building the business, but also attracting investors because they know they're working in an environment that is clear. Say that tomorrow you don't wake up and say we are closing off on processing data in a certain way, because if there's already a framework, then it opens up for new businesses and new business models to emerge. Yeah.
Thank you. Trust has been a recurring theme today in today's discussion, whether it's in digital payments or generally digital products. And I know you've mentioned, you've very likely addressed the next question. Stella did mention that, well, not specifically, but that you work together, and there's a project to translate the laws into the local languages. In some of the projects that you're handling, could you specifically speak to what UNCDF is doing for the rural people, the people who might not speak English, yet these laws and regulations are in English?
Yeah, so the question on inclusivity and people who really don't understand the aspect of privacy and how we take them into consideration, I mentioned it in a way. On one side, it's really providing the means for people to know what to do and where to go if they have questions about data privacy. So when we're working with Stella and building this online channel for people to report cases, and we insisted on things like, no, we need to offer the population with phone line where they can call. Not everybody has access to the web. We need to offer channels like USSD. So thinking through the typical rural or low-income Ugandan who might not have access to. So in building the channels through which a person can complain about a breach or can know what's happening with their data, making sure that we are able to include everyone. The translation into languages, I think, is a to-do. But the inclusivity aspect is not just on the users. The inclusivity aspect is also on the supply side. Because when we put in place a law that requires for certain standards to be adhered to, and yet we know that most of our innovators are young and upcoming, and there is a cost to compliance, then that law is actually, in a way, breaching... I'm with legal people, maybe that's not right. But that law, in a way, is leaving out some people. Okay, so there is a law, a framework, it's really good. But one of the things, and speaking with Stella here, is as we put in place this law, how do we also enable the young and upcoming innovators to comply without pushing them to run fraudulent businesses? And this is where I think we need to also put effort in developing innovative solutions around getting startups to comply. So for example, the law requires me, and that's an inclusivity thing, because a lot of the solutions today that go deep rural to support farmers and all that are actually being innovated by young and upcoming startups. So if we are to support them to comply with the law, then it's worthwhile to support innovative ways of being compliant with the data privacy and protection law. And that requires, so for example, if I need to authenticate a client's identity, okay, ideally I will collect and keep. And in that case, I have to comply with what the office requires. But that's very costly for me. And there are new solutions that can be innovated around aggregating KYC and be able to authenticate without holding it. And I think by us identifying such solutions and supporting them, that will, one, drive compliance, but two, also promote innovation. If we drive compliance without supporting innovation, in some cases we will, it might have some negative effects on young innovators coming up. So inclusivity, both thinking of the users, but also thinking of the builders of solutions. Thank you.
Thank you, Richard. In Devil on the Cross, Ngugi wa Thiong'o writes, well, there's a quote that, just because we cover the pitfalls in our compound with grass, we cannot pretend that our children will not prance around and fall in those pitfalls. So we commend the civil society being a checker of the regulators that we have. And I'd like to hear from Juliet the perspective of the civil society, especially regarding the law itself and the implementation of the law.
Good afternoon. Can you hear me? Great. Just by a show of hands, I'm always curious to know who is in the audience. How many of us are lawyers? Nice. How many of us are from the private sector? Nice. How many of us are civil society? Nice. 2 of us. And how many of us are media? Awesome, that's exciting. So there's a good representation of individuals, so that's fantastic. But that does not always happen when we have convenings such as this, and it's something that we have witnessed over the years when interacting with Nita and Stella, when discussing the Data Protection and Privacy Bill into law now. I think one of my first interactions with the data protection in Uganda legislation was when it was still in the bill format, and we were providing commentary to it. NITA had invited the Collaboration and International ICT Policy for East and Southern Africa, CIPESA, that's the organization I work for, to provide commentary on the bill at the time. And of course, being civil society, we raised the concerns that our community generally live with or face with when doing the work that they do as human rights defenders, as journalists, as social justice warriors. And one of the issues at the time was the issue around the oversight mechanisms. And even now, in the current format, the oversight mechanism is something that we still have queries about. At the moment, it is such that a judge is all that's required, right, for a warrant to be issued. With, you know, well, we've always had queries around that. But that's besides the point. What I wanted to talk about actually was the experience of being on the other side of the law as a civil society entity, as a woman also, and as a journalist. And while there's been a lot of conversation and discussion and progress with the data protection law in Uganda, which we commend the country for having, there still remains a whole host of concerns around it, of mistrust about it on the other side, especially when we're constantly dealing with queries about information getting into suspicious hands, information being demanded of sources, for example, of human rights actors by individuals who will not really indicate whom they are. So there remains a sense or a perception of mistrust in the law, especially as it has, you know, promoted a culture of self-censorship amongst some journalists, some human rights defenders, despite us being here and recognizing the efforts that it has actually, the developments rather that have been, the strides that have been made in recent years to the benefit of the digital economy, for example, to the benefit of the state interests in cross-border relationships, perhaps. We still see a persistent gap in its application and appreciation by some of the more vulnerable members of our community. And that's in regard to how the idea of data protection has evolved in those communities over the years, and it has evolved in a segment of suspicion and mistrust through to one that remains one of suspicion and mistrust, perhaps slightly reduced because of the efforts of entities like NITA-U in trying to be more proactive and transparent with what the law stands for, what it can do and should be doing, but also in comparison to what is happening in neighboring countries. For example, in Ethiopia, at one point they were using a similar framework to almost limit the extent to which citizens get access to public services. This is a law that is meant to protect your rights, meant to enable one to exercise their rights, but at the same time is limiting their access because of clauses in it that call for the requirement of biometric data to be, quite a lot of biometric data to be handed over to the state with rather patchy or suspicious clauses in their documentation. That was the case of Ethiopia. In Kenya, at one point, they had a framework which was almost allowing debt collectors to use personal data handed over to them while, you know, looking for loans and various services. Such entities were using the information provided to then go out and shame people who had defaulted on their payments. You know, so bearing that in mind, Uganda has not fared too badly. But despite that, civil society remains one that has concerns in how the law is applied, how it is recognized by various actors. We can give the case of women who have fallen victim to issues such as non-consensual sharing of images. In some of our interactions, there still remains a sense of mistrust in the law because some cases have been reported to various police stations or people within the law enforcement system, only to have the information, such as the images that were shared further beyond the corridors of law enforcement agencies. So if a law enforcement agency is going or infringing upon your data protection, what trust do you have in the system despite the presence of a data protection law, especially when you don't see much repercussion given to or faced by those police officers who have been involved in the leaking or distribution of such information. While these cases were pre-2019, or just before the release, or rather the enactment of the law, that sense of mistrust still prevails. And it's an area that needs a whole lot more considered effort by the various entities, not only by NITA, but by the media in how they report about some of these matters, by the private sector in how they utilize some of this information. Some of it sometimes gets sold. Lord knows for what reasons or whom is consuming that content. But yes, we just need to appreciate that there's still a shady underbelly when it comes to data protection in the country, and those are the efforts, which is why we're pleased to be in spaces such as this to remind ourselves that there is still a journey that needs to be worked on for civil society, for the media, to fully come to a level of appreciation of the law in its current form.
Thank you, Juliet. Before we go to the next question, well, at least people who often make assessments to pay for transactions, especially lawyers, company incorporation, mortgages, and whatnot. Previously, you'd go to the URA portal, you fill out the payment details, well, the name of the taxpayer. Very recently, the system is now requiring a mobile number. And usually, if the lawyer is making the assessment, they have the details of the client, but you probably do not want to put the client's number in the system. And what I realize is if you trick the system and put 0 to 9, or rather 0 to 9, because those are 10 digits, it will still take that number as a phone number. And I do know there's so many government offices that are moving towards e-government. In light of this movement, what are some of the challenges that you foresee that we're going to have, especially regarding around data protection and privacy?
Well, you have just raised one. The mere fact that the ordinary individual, non-techie, can override some of those aspects that perhaps are there as security checks and balances is already a concern. If at a government level, one can navigate the system so easily by simply entering the numbers 0 to 9, what then happens to other data that is input in that system? How accessible is it by third parties? Another thing that we've also picked up with some government entities is, despite this movement to e-governance, how many of the individuals within the various MDAs are actually adhering to the systems in place. A basic one is the use of email addresses, government email addresses. There's still cases where we're engaging with individuals in these entities and they are using a Yahoo address, but dealing with highly sensitive information. Yahoo experiences breaches every now and again. These are made public. They, issue transparency reports. But why is an individual in a government entity dealing with sensitive data that should be, perhaps in a better secured emailing system using a Yahoo account. So while we are moving towards e-governance, the effort needs to begin a whole lot more strongly within the government structure itself. E-governance is a fantastic thing if utilized well. It has a potential of allowing a whole lot more civic engagement, civic agency, interaction, transparency and accountability, and all those are areas that we'd really love to see a country like Uganda prospering in. However, the gaps, as have been pointed out, remain. But also it goes back to the issue of trust. How much of my information do I want the state to have? What safety nets are there for me as an individual should my data be leaked? Do I trust what the law says? And this is in reference to those cases that I mentioned of some women reporting their cases and having the information end up in third-party hands. So navigating to a space where e-governance works better, works for all, is not impossible. We have the data protection law, which is a fantastic enabler for e-governance systems to be put in place, but those systems need to be watertight as avenues for data processing, for data. What does the amount of data they provide mean for the sources that they work with? How far does the information, how much information provided can allow for one to create a profile of whom they're working with? Location, for example, movements and things like that. But all those are beside the point of e-governance. We're excited about it. It's important, but we need to be aware that for many, the concerns around data protection, privacy, the safeguards, the oversight mechanisms are areas that they still see a gray, still dominates quite a bit of the narrative around the future that it potentially has.
Thank you, Juliet. Do you think there is a potential of legislation and policy itself curtailing data privacy?
Well, many of you guys, I'm speaking as an unlegal person now, like my colleague mentioned. I think many of Uganda's laws crisscross each other. We have seen with the recent CMA, some of the clauses there are going into the territory of the Data Protection Act. We have seen issues such as access to information law, also almost walking over some of the areas that data protection law navigates. So while laws are supposed to speak to each other, they sometimes contradict each other, and that is something that we always try to highlight when providing commentary, as was done when the data protection law was being developed. Because some laws give with the one hand and take with the next, and these are issues that we need to be well aware of when assessing these laws, when doing the research that supports the advocacy against or for some of these frameworks or legislations that we have in the country. But most importantly, it also needs to appreciate the role that a country like Uganda wants to play beyond its borders. When you have contradictory laws, it sometimes defeats the purpose, as Richard also pointed out. You have a law, it's fantastic, but it's expensive. What other avenues can be utilized to make the law more affordable without going against the law or going against another law in its place? We just need to recognize that in developing these laws or providing commentary to some of these frameworks, that there is always the opportunity for contradiction. for legislation to override each other, for legislation to compete with each other, depending on which law is being worked with, such as the Regulation of Interception Act and the Data Protection Law. There's a lot of the many clauses that speak to each other, take away and give to each other, but nonetheless they remain in place. And the system, we all learn how to navigate society with them in place and continue building the evidence required to advocate for the change that's required when needed.
Thank you very much. I would just like to also share, specifically with the Computer Misuse Amendment Act, was that the Parliamentary Committee on ICT was advised through Uganda Law Society, civil society, when the amendment was still a bill. And they echoed that, most of the provisions you're seeking to amend exist in other laws, whether it's Electronic Transactions Act or the Data Protection Act. But, well, we woke up and found that there's another law. So it could potentially lead to a situation of a principle of double jeopardy, is that if you breached the Data Protection and Privacy Act, you very likely did breach provisions within the Computer Misuse Act. So if we cannot have the harmony, or if we do not have our lawmakers taking this feedback from civil society and persons, they have said, hey, we are willing to listen, but then you wake up the next day and now let's go to court, and then that's so many other years of fighting a legislation we could have nipped in the bud. I would like to move over to Priscilla. Stella mentioned data protection by design, and it's the new fancy word too. And I know within the telco sector, but particularly for your organization, is you deal a lot with having to comply with cross-border legislation. So you have the GDPR, you have the Data Protection and Privacy Act, and any other legislation that deals with data protection in so many borders. So I would like you to talk to us about data protection, and specifically data protection by design, as opposed to data protection by default. Thank you.
Thank you very much. Thank you, my fellow panelists. I'm learning a lot. It's not just fancy. It is basic when you understand privacy by design. It is building privacy into every step of your operation. For example, we are here at the hotel. From the gate, here they did not ask me to sign in, but some gates ask you to sign in. I came up here, I signed in. I sent my email, you have my email address. And so building privacy by design would mean that the people at the gate have a retention policy that after this, because I'm here for a purpose, these names are here for a purpose. After we are done, that means you either ban the names or you destroy them in one way or the other. KTA would design, privacy by design would mean that after this conference, either you discard my email or you let me know. I will be using your email to invite you next year. Is that okay with you? So privacy by design means that you either have physical systems to have privacy into every step of your process or your operation, or you automate. And those are the emerging trends with those, countries and organizations that can afford it. They are automating it so that the client, I don't have to be disturbed. I don't have to receive a call from Monyonyo that can I discard of your email or your phone number that you left here when you entered for a day visit. So the system should automatically clean out my information. So privacy by design basically is putting privacy at every stage of my operation, even at my home, I should not be able to give out my helper's number to anybody, and everybody at home should know, by design. And privacy by design and default are not so different. When you build privacy into every stage of your system, then privacy becomes a default. That, for example, because privacy has been designed into the contract negotiation, into the delivery, into in the field to the customer, or into any meeting or any email. So by default, I will not be able to share a customer's information. A client, say I'm dealing with retail. We had Boda Boda here. If if they have privacy by design into their policies, into their daily operations, it means by default, the rider will not be able to forward my number to another rider without my consent. Say I've got rider Juma, and then rider Peter is calling me. I have every right to go to Stella and complain. I don't know how Peter has my number. Jumia is giving out my numbers to people I have not agreed to. So then it becomes by default that in every area of your operation, because it has been designed into the policy, into the processes, by default as you execute, I have said many words, but I hope I'm making sense. By default as you execute, then you're mindful of privacy in every part of your operation.
Thank you. What are the nuances of data protection and privacy within the tech space?
Okay, so the gray areas, they're basically, these gray areas, first of all, come one with trying to balance the right.
Sorry, Priscilla, before we go to the gray areas, the nuances, what's new within the tech space regarding data protection and privacy? Thank you.
So there are new trends, but I just wanted to give you a bit of a background, yeah, to the new trends, because they are both positive and negative. So there's a challenge trying to balance our right to privacy plus other rights, like right to freedom of expression, the press is here. And then also there's a challenge of interpretation. So because of that, there are a number of emerging trends. One would be, for example, the issue of reasonable. People are designing their policies. Many companies now, multinationals, even national companies, they are designing privacy policies. So what is emerging is that in order to sidestep the GDPR or to be comfortable in your business, then I will set a very low bar for reasonableness, because the law is that you should take reasonable steps to protect the privacy of your customers or privacy of individuals. So many companies are doing the bare minimum, or many organizations, because there's no hard and fast rule for reasonableness. So that's on the negative, that there are challenges with interpretation. But on the positive, a lot of companies have policies anyway, and they are moving towards having data privacy policies. Many organizations are doing that. They are also having data privacy officers. This is a position that was not there before. Now they have to have data privacy officers, because we realize that it's actually, it's a very engaging position. Previously, companies, another emerging trend is that, we used to do audits for finance. But today, you have to do a privacy audit, because how can you protect what you don't know? So it's a very engaging position that now the organizations, every organization of whatever size, needs to know what individuals' information comes into my hands. Do I control it? Do I process it? And if so, if I'm processing it for a third party, am I following their policy? Am I then following also the national law? Am I following the GDPR? Depending on how far-reaching your business is, you may have to comply with a whole set of laws. So the position is permanent for the data protection officer, and now there's also what they call the DPIA, that's the data privacy assessment. You do an assessment of all the data that you have, and the risk areas, the risk of the data processing steps, where the risk arises. So that is also another audit that many companies are doing or ought to do, so as to know what information to root out, what to discard, and how to improve different processes. Another trend also is continuous internal training on the subject. It's happening in different companies, of the staff, of the partners, so that the business can grow. can grow together with your different partners, because it doesn't help if I'm doing so well and yet my suppliers and clients are not complying. Compliance challenge with any of my close partners will definitely affect my business. So there's that joint growth. And then, of course, in Uganda, registration, as Stella has said, we are registering and we are learning continuously. Thank you, PDPO team. They are giving us free trainings. I don't know how long that will last, but we are enjoying it. And then, of course, for professionals, the certification, there's a lot. Tell me to stop. The certification now, there's like, comparison. Yeah, there's like SCCA of privacy, so that's also on professionalizing. Yeah. I'm going to stop myself.
It's actually woven into my next question, which just to throw, or rather just to put it out there, is there is an ongoing debate, and still I guess we can debate this some other time, that the provision requiring organizations to have data protection officers is not entirely mandatory for all organizations, because it says that there will be officers or institutions that will be required to have data protection officers. But in practice, and the implementation of it all, is that every organization now that collects, processes, or controls data is being required to have a DPO, which ties into the challenge that you mentioned, interpretation of the law. So as a data privacy practitioner, what are some of the challenges you've encountered with this, the law and its implementation?
Okay, thank you very much. Data, like it's ambiguous, if ever there was ambiguity. So, and you can't protect what you don't know. So that was the initial challenge, understanding what we need to protect. So you need, and it was new, so a lot of people didn't understand. They thought it was an extra. They just thought that it was, like that little fork you don't know what to do with sometimes, an extra. So we had to get the organization to understand, no, this is mainstream. And when a law comes and there are penalties, so the organization understands very fast. So then you can get information out of people. So the easiest way to bypass or to manage that challenge is to break it down into departments. So you have the HR, you have the operations department, finance. So you task a person. It's really a joint job. You task an individual in there to tell you what, there's procurement, what personal information do you deal with. And then from that point, there's that on the one hand, understanding the information that you have, the individual's information. Then on the other hand, the internal policy. Now this policy is born out of the GDPR and of course our local law. The policy will describe what privacy is, but it will also go into a complaints procedure. If ever there's a complaint of breach, what would we do? If a staff, for example, it doesn't have to be so complicated. If a staff says the CCTV image was used, for example, in an internal advert in the organization, I'm not happy. Or they took pictures of me at a staff party, and I'm seeing it on the billboard internally. So if that came, something as basic as that, I'm not even talking about external, how would we handle? Who would they complain to? So just to go back to support the position of DPO, you find that it is inevitable, because when you have a complaints procedure, who do they complain to? Will they complain to the HR, the admin? And if they did, then that person would treat it as a by the way. And yet this is mainstream, and it could lead to a hefty penalty, or it could lead to reputational damage if someone decided to go out there on social media and say these people are using my images without my permission. So on the implementation side, practically in an organization, when you assess from the different teams what data you need, and on the other hand, you have a policy, but you need a set of hands to execute. So that's why you actually need a clear line. of a team, a clear team. Report to X, and this is the team maybe that will sit and review the complaint, and then when the complaint is decided, the report is given to either the internal management, if necessary, if it's going to the media, the board. So it's how can I say, multifold. But the most challenging is understanding, and once you've defined what private information you're dealing with, the rest, then you just have to follow your internal policies and the process you lay in place. So for us, just to give you a heads up, HR was easy. So we started with HR, and then HR starts to organize, and then we trained the teams. If I want to access my contract, I don't have it from 2015. This is the little form, the little e-form you can fill, and HR has to give you your contract. So we did we did a moot. Lawyers would understand it. We did a practical, and HR was easy because the data subjects are in the company, and then the controller is in the company. There are some processors there on the HR team. So that's just bringing it to practice in our different organizations. Yeah, then you took that to the different departments. Yeah.
Thank you very much. At this time, I'd like to open up for any questions that we might have here and also online. You'll be required to come here since we have one camera.
Thank you so much, our esteemed panelists. My name is Isabel Tuonjere. I am the Legal Officer and Data Protection Officer at Labramas, Uganda. And my questions will be directed to Madame Stella and the lady at the end. I'm sorry, your name has kept my mind. But firstly, with the PDPO, thank you so much for the guidance you're giving companies and entities that require to be registered on what they need to do and interpretation of the law. And my question is sort of twofold, but tying into aspects you both talked about. The challenge of interpretation that you brought up is something that we face. I can give two examples, one being consent. So we have sections in the Act that will break down the particular requirements that qualify or justify affirmative, express, and clear consent from a data subject. But you also have another section that talks about what we call implied consent, in the sense that if information or personal data is needed for the sake of a contract or by the government, then consent is not necessarily waived, but isn't carried out as, articulately as it is in the other section. Another example probably is, as you talked about, the cross-border transfer or flow of data. The fact that in countries where you cannot prove that there is an adequate standard of data protection principles to the standard that is established under our law, there are those issues of firstly finding out whether such a country does, and secondly also just borrowing from the international regimes, because we know EU in that situation requires a contract, for example, to have standard contractual clauses that basically input the requirements of the law within those contracts, so that data protection is achieved. So when it comes to that general problem of interpretation, that as a company we have to sit down with the Act, and they come to the data protection officer and they're like, okay, Isabel, tell us, what should we do? Have you considered practice from other areas of the law with regards to this international regime? Because this is a problem that has always existed. For example, with human rights, as the Committee for Civil and Political Rights, when they were drafting the ICCPR and the ICSCR on human rights, they had that same problem of interpretation. And member countries were doing the same thing that data protection officers are doing, drafting privacy policies with the minimum, threshold and justifying the fact that this was reasonable. But we don't have case law to determine what is reasonable. We don't have, cases from a sort of tribunal that would inform, the qualifications and definitions from this. And what the Human Rights International Legal Regime started doing was creating what they call general comments that break down when the ICCPR, for example, provides for the right to, freedom of expression. And they have 5 pages that break that down, even without, cases or anything. We also have internationally, especially with the application of the GDPR, the European Court of Human Rights that has helped with that. But that's on a GDPR level. When we come down to the DPPA here for us and the regulations and understanding consent and understanding the requirements of an impact assessment, there's still a lot to be done in teaching people what it is. Will it be that each time we don't have a question, we're asking for a legal opinion? Just what are you doing? And I'd like to also know your experience in that as a, handling data protection. That's my question generally. Thank you.
Thank you very much for the presentations. My questions are very general and they go to all the panelists. My name is Muhindo Morgan. I work with Unwanted Witness. The first question is in regard to the emerging technology or the evolution of the digital age. We have had people speak about the Web 3, that we are transitioning from Web 2, which is basically an interaction, and that's where most of the applications we use are based, that they are interactive in nature. But we are transitioning to another stage of it, which is Web 3, and it decentralizes information. So my question is, do you think that the Data Protection and Privacy Act will still be a viable law 10 years from now when we achieve this evolution of the internet of digital technologies? The other question is on the law itself, the Data Protection and Privacy Act. When you look at Regulation 3 of the National Payment Systems Regulations, it requires any person applying for a license from Bank of Uganda, you must have a cybersecurity plan. 2, you must have a privacy policy attached to your application. I understand this is a law that comes after the Data Protection and Privacy Act. Then my question is, are we thinking of amending all those laws so that whoever applies to any regulator, they must have these requirements, because almost every business is going digital, including the NGOs that you may be talking about. They have websites. So is it now, are we going to amend all the laws, or are we supposed to amend all the laws to provide for such kind of mechanisms? Thank you.
All right, I think we'll have the third question, then we have answers, then we can have more questions. Thank you.
Thank you so much, our dear panelists. My name is Patrick Kazubwe. Just different from each and everyone. I'm a legal scholar at Uganda Christian University. My question, it's a very straight one, which goes to all the panelists. And just like other legal scholars in schools there, Makerere, UCU, the way they are confused right now about the Data Protection Act of 2019 and the new amendment of the Computer Misuse Act, because we are seeing these two acts being in play. They are all valid. They're having valid, valid points and sections, but at some point they are contradicting. The Computer Misuse Act will get to say that, the punishment for this, for such an offense, it will take 7 years, and maybe a punishment of not exceeding this particular occurrence point. And to contrary, that's what exactly the other thing is to bar from happening. So how are we going to, or how have our regulators and then these people who help us in policy makings, how are they going to help students at least get to capture what exactly they have to exactly know without having the contradicting statements or contradicting laws? Then secondly, how are these bodies which are entitled at least to get to guide the regulators, how have they been able to go deep to the ground to make sure that at least people who get to do this, people who get to draft this, are exactly drafting the valid law that can get to help the nation. Thank you.
Thank you. Before I hand over to the panel, I just want to clarify to the second question that we received. Stella did mention that her office is has been working with the central bank to ensure that the fintechs, specifically under the National Payment Systems Act, are complying with registering with the PDPO. But to mention also, I do know that under Regulation 3, it does not specifically state that the applicant must have a data protection and privacy note or, yes, note. It does say, yes, you must have your cybersecurity. However, in the regulations, it calls upon all participants to comply with the Data Protection and Privacy Act. And I do know that FITSPA, being the Association of Fintechs in Uganda, has taken up the mantle of helping fintechs register with the PDPO. So I think that question, maybe Stella, I think we've answered that, but I'll let the panelists take it on from here, and then we can have more Q&A. Thank you.
Okay, I'll answer the question from Isabel Boremas. The challenge of interpretation. I think this is not unique to this law. Whenever you have a new law, that's why we even have the judiciary. You, as lawyers, we interpret based on our understanding. Within the Data Protection and Privacy Act, the PDPO is mandated to provide guidance where you need that guidance. And I know organizations that write to us, we respond and provide that guidance. The other thing that we've done, we have a very exhaustive, frequently asked questions. Some of it is on your desks, on your tables in front of you. So when we interact in sessions like these, we keep tracking which are the most frequent questions, and then we update. Of course, the most update version would be on our website, because once you print, you've printed those copies. So we continue to provide this guidance. Now, on the issue of consent specifically, in law we always have what we call the exception to the rule. The rule is, when you're collecting my data, get the consent. But we know there will always be exceptions. And some of these exceptions that you're talking about are under Section 7.2 of the Act, where it's a public body. URA, I'm mandated to collect this information for you to be able to pay your taxes. URA can go to NIRA and pick up that information. Because they've gone directly to NIRA, they will not get your consent, but the law allows them to do that for certain purposes. If we have a contract between us, that is where legitimate interest comes in. It means that within that contract, you've already, for instance, allowed this organization to receive information. The case in point I can give is where individuals go to banks and they want to open bank accounts or they want to borrow money. That form normally already has this content. It's just that people don't read it. You'll allow them to access your records with the Credit Reference Bureau so that they understand your behavior within the banking system. You'll allow them for KYC. Their laws actually require them to peer, let's say, with NIRA so that they confirm that the Stella who has walked into ABSA at Bugolobi branch is actually the Stella I have to deal with. So those are the exceptions. It's not that it's not clear. I think what I would encourage organizations to do is to use the first rule as much as possible. Sometimes we do this interpretation in a way to deny this right to this individual. But what would encourage is responsible collection of data. There's nothing wrong with you asking for consent, and we encourage people to apply or to request for consent. However, these exceptions are there to make sure that this law is not also a deterrent to businesses proceeding, to government collecting taxes, to investigations being done and things like that. And what I can assure you, these exceptions, you'll also find them within, for instance, the GDPR, because they know, yes, we have to exercise this right to privacy, but it is not an absolute right. Of course, on our side, as much as possible, we are on email. We are really a digital enabled office. So most people don't even have to walk to our office. You can call. We are relying on the NITA service desk, and people do get answers to the best of our ability. We may delay slightly because we are very few on the ground, but our heart is in a good place, and we are here to support you. Of course, we expect that being a new law, I think I'll answer the question from, there was another question related to lack of jurisprudence, the cross-border transfers. These precedents have to be created. Kenneth there will tell you that when a new law comes into place, people will have different definitions, and we have a system in place that enables us to finally agree what is the common understanding, and that is normally determined by our judges. Of course, within the law, we guide. If someone objects, within that very law, they have an appeal, a right of appeal to the minister. If they disagree with the minister's decision, they can still go to court. So there are venues that will enable us get there. Do we use other benchmarks? Yes, we use a lot of other benchmarks, but for us what is important is that we customize it to our needs. For example, I had the comment on data protection officers. Indeed, it's not mandatory to have a data protection officer, but organizations that choose not to have them, in many cases, will struggle with compliance. You'll note that the law specifically said designate. That was mindful of people like Richard was talking about, like small fintechs that are not able, for instance, to appoint a data protection officer. Within Europe, the requirement is appoint, but appointing requires you to have the resources, it requires you to have the skills. In our case, even within government itself, we do not have the money to be able to appoint data protection officers. So this law actually enables you to designate Stella, who is doing something else, in addition to that, to add on data protection. And that's why you find that in our registration process, when we ask who is your data protection officer, we then ask, are they doing any other role? So that we understand these people who are data protection officers, what else are they doing? We know, for instance, they are lawyers, they are IT people, they are auditors, they are compliance professionals. Those are the people that we are seeing. But it was customized to our needs. I know civil society would want, the right to privacy, appoint a data protection officer, but sometimes it is not practical in our setting. We have to know that while Europe has been at this for over 50 years plus, in Africa, the first country that passed a data protection and privacy law was Cape Verde, which happened about 20 years ago. I'm not sure how compliant they are. Within East Africa, Uganda was the first in 2019 to pass the law, followed by Kenya. Rwanda has also done so. Tanzania has just published their bill in October. So it is a journey that we have to start. We encourage discourse about these issues so that we develop a secure, ecosystem. The requirements of the DPIA, issues to do with cross-border transfers. What we are lucky about is that within our regulations, the office is mandated to provide that guidance. But you note that if we are, let's say, to do the adequacy analysis, it takes a lot of work. We may even have to outsource a consultant to go and look at, these countries. Do they have laws? Do they have data protection authorities? What are their enforcement mechanisms within the law? Do we see actual enforcement happening within those organizations? So it takes time, and eventually we'll get there. What we are trying to do right now, like what she's talking about, the monthly webinars, I hope you'll be supporting. We'll call you one of these days to talk at those monthly webinars. We hope that they will continue. The beauty about digitization is that we don't have to hire this room like KTA did. It's basically internet, which is available from our backbone. We invite people. So we speak as PDPO, however few we are. Then we invite people like Kenneth, we invite people like Priscilla, who we know are able to provide their experience in terms of applying these laws. So that's why you see in our webinars, we have different people. It's not only us speaking. I think we did talk about these DPIAs. So if you go to our YouTube channel, all our webinars are recorded. If you go there, you'll find some content there. Please just listen to it. The reason we are doing all this is because we are so few within the office, so few. We want to push out this information so that wherever you are, as long as you have a general understanding of these issues, you're able to train yourself as we develop this space. Muhindo asked, will this, is the law, I think, I forget the question, but it was about its viability for the years to come. I think it is, because it's a principle-based law. When you have a principle-based law, as long as the principles endure, this law will still be applicable. So whichever technology you're going to bring on board as innovators, I believe this law will still be, will be able to apply. Thank you, Bonita. You really answered the fintech question very well, so I won't talk about that. The legal scholars, we always, where there's a contradiction, we have a modality of dealing with it as lawyers, so this is not really very different. Thank you. I think there was something for you.
Yeah, that's better. I think I'll just supplement on cross-border transfer. By now, you probably know the countries to which you transfer data a lot. So it would be good to get their legal regime and compare. And on that, then base a data transfer agreement on that. Now, basically, a data transfer agreement is country Uganda and country Isabella agreeing, or company in Uganda, company Priscilla in Uganda and company Isabella, for example, in Germany, agreeing that we shall transfer, we shall share data under the following conditions. But it is agreed before we share data that your, obviously Germany has, I think, the most stringent protection, that your protection is XYZ and my protection is XYZ, and they actually merge. They are similar. In Africa, Uganda and South Africa have a very similar regime. So it would really be true to say that our protections are similar and we have agreed to share data for these purposes. So that DTA, or data transfer agreement, basically saves you time. Every time you have to share data, you don't have to ask so many questions. So that's one of the practical solutions you could use for data. Consent, we are an ICT company, so we have privacy consent technologies. So you can actually consent But also these technologies help to preserve privacy. They anonymize data, they pseudonymize it, meaning they take away the names, they take away the identifiers of the data. So the data is practically faceless. It cannot identify an individual. So those technologies also help to speed up your work. Otherwise, you know, the whole month the company might only be doing, is it privacy? Is it that you may not actually deliver to your customers? So those are some of the solutions you could include into your business. Thank you.
Thank you very much. We are at that point in time where when you're watching a limited series that has, say, only 4 episodes, and it's very thrilling, but you know, you're about to come to a close. We have 5 minutes remaining. I'd like for us to take one more question. Unfortunately, just one more question, and then we'll have parting shots and close and go to the masterclass. I saw her name up. Well, okay, let's do 2 questions then, but I hope they're you know, brief. Thank you.
Okay, thank you. My name is Francis Yarohanga. I'm a student of law at Uganda Christian University. My question will be directed to Richard, and my question is on ownership of data. So we have seen Apple improve its software to empower the user on how much data will be collected by apps that are on the App Store. And we have seen that create an issue between Apple and Facebook. And in the same way, with the advent of technology, to what extent are we going to see ownership of data be within the ambit of the user, that I solely control what information a company gets from me? And we're also seeing people click on user agreements. People say agree without reading. What is in place for us to ensure that the user privacy and safety agreements being placed before, you know, the screens of users actually comply with the data protection and privacy laws being enacted in Uganda? Thank you so much.
Good afternoon, everyone. Good afternoon to our esteemed panel. Thank you so much. I think it has been very insightful for all of us. My name is Jamina Apio. I'm a lawyer and an expert in IP and ICT. When I was coming for this session, I think this was probably one of the exciting ones. I was doing Inky Pinky Ponky, and I was like, which one should I really go for? And it had to be this, data protection. Now, I have two questions, and I think maybe Stella and Priscilla will be best placed to answer this. When it comes to big data, the other day I decided to go and try a new restaurant, and had my phone obviously on with internet and everything. And then the very next day, they send me a message about, oh, how did you like this restaurant? Did you enjoy the meal? You know, it's like they're literally following me, and they're tracking every single step of where I'm going, and I'm like, okay, so this is not funny anymore. But when it comes to big data, data is basically an asset. It's very similar to IP. I think parts of the definition of IP includes data. Now, big companies in the US and Europe basically sell data. But if you look at our privacy laws, they're very strict terms and conditions about how data must be utilized. Stella was explaining to us that you have laws which basically say after a certain period of time, that data is going to have to be erased. You have to destroy it one way or another. But let's really be real here. The practicability that any data processor, collector, or controller is actually going to follow and destroy that data in 20 days, 30 days, is highly unlikely. So my question is basically on the practicability and understanding how do we actually control and understand how data is actually going to be utilized, it's going to be destroyed, it's going to maybe subsequently also be sold, because they actually sell it. That's what's actually happening out there. I mean, KTA has had this amazing session. They have data. They need to know the numbers of people who attended. That is information they have to sell. I mean, Ken, please don't sell, don't be destroying all our lists and things here. But it's information that is very, very important. So my question is basically to literally try and understand how do we streamline all of these regulations, all of these policies, and yet still open up room and foster innovation, foster more services in the big data arm. We have digital economies, tech, everything is going technology. So if you put stringent laws and regulations that are telling people, destroy this after 30 days, and yet this is information that they can actually utilize and sell for government's purpose, by the way, as well as for the public. What are the controls? What are the discussions that are happening internally to support all of this? Then my second question is really also, again, back to practicability and really where do we draw the line? If you look at the definition of a data controller, it's basically a person who controls data. So that's me, that's you, that's literally every single person out there. If you walk into a law firm has employees. If I'm hiring someone, I'm going to take his information. If you go into a supermarket, they have employees, they have customers, they're going to take that information. So where do you draw the line in that definition? Is it actually there, or is it completely open-ended? Because at the end of the day, we're going to end up having everyone registered as a data collector, a data processor, and a data, what's the other one? Controller. Yes. So those are my questions.
Thank you. We'll have Richard and then Stella. And as you do respond, please give us your parting shots, and then we'll have last parting shots from Juliet and Priscilla. Thank you.
Thanks. Good question on how do we really take control of our data. I think most of the data protection frameworks, power belongs to the owner, who is you. The question is, do you really have the power? And it's up to you to claim it. One of the ways to do it is to know what you can actually claim for and how to claim for that. My biggest bet is that most of the Western companies that are collecting and making a lot of money from our data actually are complying. What they've done is they've sent you stuff and you've ticked yes, yes, yes. In Uganda, I'm not sure because this is all new to us, but most of the Western companies, I remember going back to my Facebook page and looking at everything I'd consented to. And the moment I deactivated that, it's like I didn't have a page anymore. There were no more feeds and all that. But in most cases, we've actually consented to things we didn't know. There's an option to go back and, is the consent English? Yeah. So it's withdraw your consent. So it's really more of awareness about what your rights are. There's actually an option for you to go back and correct what you might have granted. So, yeah. But I also think, so the use of data is not bad. It actually is enabling a lot of new stuff. And that's my parting shot. A lot of innovation is coming out of the right use of data. The wrong use of data might not be good and sustainable, but we need to be sure and indeed have control of our data and be sure that it's being used for things we have consented to and that we subscribe to. These things of at every other entry point, they have my name and even close to my date of birth. Maybe those not. But for the rest, as long as we can consent consciously, I think it's fine. Thanks.
Thank you, Richard. You did answer some of the questions that I had. Or the questions that I was supposed to answer. The issues raised by Jamila? Yes. Jamina. Okay, beautiful name. The issue of big data, indeed this is upon us. And I think when I was speaking earlier, I talked about some of the measures that are being taken by government, the National Data Strategy, the 4IR Strategy and Policy, the AU Data Policy Framework is meant to address the issues that you're raising. Yes, organizations need this data, businesses need this data, but they have to protect you. Of course, I suspect that when you went to this restaurant, you may have accessed their public Wi-Fi, and because of that, they are able to see some of your details. In terms of practical enforcement, on our side, what we are trying to make sure is that these people are actually registered. That Wi-Fi provider should be able to use that information for that purpose that, you know, that they've indicated to you. Would expect that when you log in, at least something pops up and tells you who they are, so that you know who is collecting my information, how long they'll keep it, who they'll share it with, and the like. Obviously, as an office, it's very difficult for us to go to these 1,000 entities and ask, have you deleted, have you done all this? What we did, for instance, in the last year of operation, we went and did audits, about 10 audits. We chose industries that we felt were high risk, or industries that we know are collecting a lot of data. We then also included people that are collecting sensitive data, either health data and the like, to understand what are their policies, how are they implementing their policies. So those audits can track some of those issues, because when we go in, we'll look at your retention policy, and you'll have to give us evidence, some process within the organization that shows you either deleted this data or not. But the person who can actually check these excesses is you, the data subject, because it's your data. If you find that this, remember, you have a right to access your personal data. So you can wake up, Jamina is not busy for that day, and you write to those people who have been sending you messages and ask, what data are you receiving about me? If they don't respond, you have a right to complain to us. And obviously, when you complain to the office, we then go into the organization and do an extensive investigation. If we find that they are not, remember, these policies are determined by these organizations. They are not determined by us, and they are not given by the law itself. The law says retain personal data for the period either authorized by law or for the purpose for which you collected it. So when you have that privacy policy, it says, I'll keep this data for 5 years. You're the one who has determined those 5 years. In the registration that we are doing, we ask, how long will you retain this information? And we receive that information, but when we start auditing, when we start investigating complaints, these companies will then be put to a test. Of course, I've seen companies that say we'll keep for 100 years. I've seen those who say 1 year, and I'm saying, really, 1 year? But it is up to them. That is not determined by the office. What the law requires is that you disclose, you're transparent about this process. The only people that can implement or that can ensure compliance are you, the data subjects. And that is why in our engagements, we are reaching out a lot to data subjects, because they are the ones who are out there. For me, Stella, my print is very limited. So that is how this is going to be done. The definition of a data controller, indeed, it is every person, whether a supermarket, whether a clinic, whether a hotel, they actually require to register. However, within the law, we are required to provide exemptions, and we are working on them this year. So far, I think the only people will exempt are where you're processing data for personal needs, family needs, and things like that. The challenge of having these exemptions is I may have, for instance, just 5 staff, but I'm a processor for MTN. Can you imagine how much data I'm dealing with? So I look small on the outside, but actually I'm accessing a lot of personal data. So let's encourage everyone. The reason we want organizations to register is for us to know who they are and for us to provide them with support. we know that when someone is registered, it's much easier for them actually to comply than if they are not registered. My last word, I want to thank the organizers of this symposium. For us at the office, we are always happy to talk about these issues and create that much needed awareness. My encouragement to everyone who is here, your privacy matters, and it's important that you take charge of your rights and enforce them wherever you are. Thank you very much.
Thank you. Let's have parting shots from Juliet and then Priscilla.
Thank you. Thank you. And yeah, to the fellow panelists, very insightful contributions. I would just like to point out that as civil society, we do share, the vision is shared for an environment where data is respected, is processed in meaningful ways to the benefit of individuals, the state, companies. But everything needs to be necessary and proportionate. We see some liberties being taken in some instances, and that's where our concerns come. We need to recognize that the individuals on the fringes of society whose data will remain being exploited. We're looking at refugees. Uganda is one of the countries that hosts quite large numbers of refugees, but how often are we thinking of their rights? There was a case a few years ago where an individual benefited from the humanitarian sector because she was selling the data of the refugees that she was collecting information from. They got a packet of food, a sachet of food or something like that, but she got the pounds and euros or whatever it is that was being taken. So these are concerns that we raise in quite a bit of our research, where we have looked at many of the issues coming up that have been raised here around cross-border issues, autonomy, data sovereignty. And you can find all of that on our website. That is cipesa.org/resources. That's cipesa.org, cipesa.org/resources. I highly encourage you to look at some of these laws from the perspective of civil society, where we accommodate the interests of communities such as the media, social justice actors, human rights defenders. And sometimes, while some of these laws sound fantastic in principle, there's always an underbelly that needs to be remembered and also understood. And that is quite a bit of the work that we do. So yes, in that respect, well done to KTA for putting this all together, for having these integral conversations around the various aspects of technology, digitization, and where it's going for Uganda. I saw discussions around green economy. Data protection arguments also come up there. Digital transformation. I mean, all these arguments are highly interrelated. So thanks for having us here. But yes, let us remember that data protection is fantastic. It's necessary, but some of the work around it needs to be proportionate. We're looking at issues such as the fees related to some of the penalties there. How affordable are they? Well, they're not meant to be affordable, but they need to accommodate the realities of some of the contexts in which we are living in. And on that note, thank you very much, everyone.
Thank you. Thank you. I think my parting shot will start from her about the fees and the penalties. Each of us is a privacy advocate. So let's help our brothers, our sisters, our workers not get penalized. Let us tell them the basics, that do not share anybody's private information. I'm always telling my mom about forwards. Can you not? You know, did you get permission? I don't care, it's your niece. Please get permission. So each of us is an advocate. Each of us is a privacy specialist in a way, in that the information we've gathered today along the way, we know the basics. Let us not share people's private information without letting them know. Finally, for the organizations that are here, the only way to start is to start. It can be overwhelming, But we'll start by understanding the basic information that you're processing, and as I said, split it up into different categories and register with the PDPO. They are our most friendly regulator, and we are hoping and trusting they will remain that way. Yes, I encourage you. We've worked the process. The hardest, I think, was identifying the data. Once you're past that, then you just continue. Law firms do, have you registered? So I encourage you, because someone may come to give you a transaction and they will ask for your policy, for your registration. Compliance now is central to a lot of business. So thank you for listening to us. Have a great weekend. Thank you, Bonita.
Thank you very much to our panelists for a very informative discussion. I will let you take the seats in the general area. Thank you to the listeners and also for participating. There's a masterclass ongoing in the Victoria Ballroom, so we could all make our way back there. But thank you so much for coming. Have a good day.